Morning. Let's go ahead and set our appearances on the record.
Good morning, Your Honor. Eric Pepperman, Will Kemp, Teddy Parker, and Grant Switzler for plaintiffs.
Good morning, Your Honor. Joe Ledoux, Matthew Kaufman, and Eric Freeman on behalf of the Rural Water Defendants.
All right. And it's my understanding the jury's here, is that correct?
That is correct, Your Honor.
All right, they're waiting. Anything else we need to address before I bring the jury in?
Just briefly, Your Honor, we have a list of the admitted exhibits to go back with the jury in blood here that we stipulated to.
Okay, and that's to the court clerk. All right. Is there anything else?
No, Your Honor, ready to proceed?
No, Your Honor, we're ready.
Okay, let's go ahead and bring the jury in.
Yes, Your Honor.
So how much time do you think we have, Mr. Gill? How much time? I don't want to put any pressure on anyone. I'm looking at
guessing
more
about
from
30 minutes, 40 minutes. Depends how, I've got, a group of slides, depends how fast I talk. Court recorder gets mad if I talk too fast.
Yeah, Judge, I think we would probably get done in 30, 35 minutes for rebuttal. So I think we just run the whole thing and then we'll.
That's what I'm thinking.
Yeah,
What do you think? Will we be done by 12:30?
that's,
For sure.
yep.
Mr. Parker, you in with that?
I'm trying to be quiet. I really was trying to act like I was not listening. I think we can do it.
Okay. Because I'll just order lunch for the jury at 12:30.
I think we have lunch already, right?
Oh, do you? Okay.
We do, Your Honor. We have lunch coming in.
All right, thank you. And you can tell them, I don't know what time, but 12:30 it'll be fine. Okay. So that's taken care of.
Just to say, we can have that tomorrow.
All rise for the jury. Please be seated. Thank you.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Okay, ladies and gentlemen, I just want to say good morning to you. And it's my understanding we're going to continue with closing arguments in this matter. And we're going to hear from the defense at this time, Mr. O'Doul.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. Thank you for being so patient and waiting. When we started this case, way back on day one, voir dire, and even before, I said this case was about damages, and that's what I'm going to be talking about today. Before I do that, I want to thank each and every one of you for being on our jury, for being patient. We have tried to put this case on quickly and efficiently. We have tried to make sure that the witnesses who were put on were relevant to the issues in the case. I think there were some comments yesterday about, well, why didn't we have this witness or why didn't we have that witness? Because it's not important to the case. The case is important to these plaintiffs. The case is important for damages. So we're not going to waste your time arguing over liability or causation. On behalf of myself, Mr. Kaufman, and Mr. Freeman, I want to thank you for being so attentive. Let's go ahead and put up our presentation, and let's go to the very first slide. So this is a recap. Obviously, we went fairly late yesterday, and I'm just going to quickly go through this. This is all information that you have heard from witnesses, from attorneys, and I'm sure that you're probably getting tired of hearing it. So, Real Water is a family business. There's approximately 30 employees, depending on what year we're talking about. Brent Jones, Amy Jones, Blaine Jones are the family that runs Real Water. They started in 2008. They believe in their product. They drank the product. You've heard testimony about Blaine Jones becoming sick from drinking the product. Blaine Jones continued to drink the product after he got sick. All the way up until the time of the recall, they drank the product. It was good. And this picture shows just you'll see the 5-gallon jugs that were being filled, and you'll see the filtration system. This is the water coming into the building. So next slide, please. All right, so you saw John Marlowe, the inventor of real water. You heard his story. You heard how he taught Blaine how to make the water. These are the mixing tanks that the water was made in, whether they were making a large batch or a medium-sized batch. The water and the concentrate would be mixed in these tanks. There's a ladder there that would pour the concentrate into the top of the mixing tanks. That's how the water was made. Let's go to the next slide, please. We've talked about the process. You heard Dr. Najam. Again, we didn't need to call another expert. Dr. Najam described it adequately. The interesting thing about Dr. Najam's testimony was that he wasn't asked on direct, how was the hydrazine formed? He had two theories. You heard us ask him how the hydrazine came to be, and hopefully he explained that adequately to you. So let's go to the next slide, please. Obviously, the concentrate tanks, the water was run from one tank through the titanium tubes back into the other tank, and then they ran it again to make the concentrate. Next slide, please. Again, we talked about hydrazine. You've heard a lot about hydrazine, how it's used in the space program, how it's been used. The only thing, again, that's interesting is there's no nitrogen in the real water process. Nitrogen came from somewhere, and you see the ends of the symbol for hydrazine. And Dr. Najam has given you two different possibilities as to how hydrazine, how the nitrogen got in the water and how hydrazine was formed. Go to the next slide, please. You've heard a lot about Blaine Jones. They've drawn a lot of comparisons to Blaine Jones and the plaintiffs. You haven't seen any medical records of Blaine Jones. You haven't seen any doctors testify about Blaine Jones. All you've heard is the argument of counsel about Blaine Jones. And so what I want to do is I want to go through some of the factual things and some of the evidence that you have heard in this case. Obviously, when Real Water started, they hired a consultant. They were doing testing. Blaine drank the water. Everybody at the Jones family drank the water. Plaintiff's expert, Dr. Hutt, she testified. Testing was done weekly, monthly, quarterly, annually for all the contaminants that you would expect to find in bottled water. That's her testimony. That's not Blaine Jones' testimony. It's not my argument. That's the fact in this case. The fact also is that that wouldn't have found the hydrazine. Okay? We're not disputing that hydrazine shouldn't be in the water. We never have disputed that in this case. Since we started speaking to you, we said there shouldn't be one drop of hydrazine. I think you also heard that from Dr. Goldsmith, who was called by the plaintiffs. Blaine Jones, he never heard of hydrazine when it was discovered in the concentrate on October 20, 2021. That was Plaintiff's Exhibit 5. That's an important date because it's 2021. The people in this case were injured before that date. Real water was tested by Eurofins Laboratory, the finished product. I don't think we have a bottle out right now, but that was Exhibit 9. That happened in March of 2023. Again, these are undisputed facts. Let's go on to the next slide, please. All right, I've given you part of a jury instruction here. It's not the whole thing. This is jury instruction number 8. On day 2 of jury selection, you heard the judge talk about the importance of jury instructions. You heard that the parties work really hard to make sure that we give you the law, and the judge gives you the law, and you can rely upon the law that you're given. And the law in this case is in the jury instructions. You're going to get a copy of them to keep and to go back with you. And they're important. They are probably, other than the evidence, the most important thing that you will see in this case. And we want you to follow the jury instructions. There were some comments yesterday that I'm going to get into in a minute about what Real Water wants. What Real Water wants is not important. Okay? I'm going to say that right up front. What the law requires, that's what's important. So, evidence is the witnesses, the exhibits, and the facts admitted in the case. Admissions, where Real Water said, we're liable. Our water caused these people to get sick. Those are facts that have been admitted in this case. You can call them stipulated facts. That fact has been proven that Real Water made these people sick. It's not in dispute. The fact that these people were sick is not in dispute. You heard every single one of them testify as to their injuries. And all of their injuries are unique, and we think you should look at every single plaintiff and decide the damages based on the testimony that you heard from those individuals. Okay. Let's go to the next slide, please. Again, this is just another way of saying the facts in this case are undisputed. The damages are what this case is all about. Let's go to the next slide, please. So, Real Water has admitted it has hydrazine in it. Legally speaking, that's called liability. It doesn't matter, it's not disputed. Dr. Najim was called and he testified. We didn't challenge that. There's never been a challenge to that in this case. Real Water has admitted its product caused the plaintiff's injuries. That's causation, that's overkill. Real Water has admitted that it is responsible for the medical monitoring costs recommended by Dr. Hudson. You saw Dr. Hudson questioned by Mr. Parker. We're going to talk about that in a minute. And he talked about the future care of the plaintiffs. He talked about all of the plaintiffs, including Mr. Henry. Mr. Henry's future care was a little bit different, but he talked about the 14 plaintiffs and their future care. And their future care was medical monitoring for a period of 20 years. They will do elastography on them, and we're going to see that. That's Dr. Hudson, who was hired by the plaintiffs to provide that testimony. He wasn't hired by Real Water. We're not trying to change his testimony. That's a fact. His testimony was undisputed. And the medical monitoring that he recommended, it's not going to appear on the jury verdict. That is undisputed. So in terms of, that's one of the elements of future damages that you heard some discussion about yesterday. The second element that you heard about was fear. Okay? As part of that, there was a presentation, and I'm not going to respond to that. I'm going to respond positively as to how the plaintiff's fear is going to be addressed, because Real Water has agreed that there will be future neuropsychological monitoring and treatment as recommended by the plaintiff's expert, who didn't testify in this case because his testimony was not necessary, because we agree. The plaintiffs, they all testified about their mental anguish, their grief, their fear, their worries. Basically, they described symptoms of post-traumatic stress disorder. And they deserve to have treatment for that. And Real Water has agreed that they deserve to have treatment for that. And that will not appear on the verdict. So what will appear on the verdict? It's four things. Past mental pain, suffering, and anguish, and so forth. Future, and we're going to talk about this in detail. Future physical and mental pain, suffering, anguish, disability, loss of life. Mr. Henry's loss of life expectancy, and punitive damages. So those are the damages that we're going to talk about, and those are the damages that we're going to ask you to make an award of. Let's go to the next slide, please. So, just as a highlight, this is not Real Water's expert, this is plaintiff's expert, Dr. Hudson, and he testified that all of the plaintiffs, except for Ms. Rasmussen, suffered from acute liver injuries. Not disputed, all caused by Real Water, not disputed. And here's the important thing. Dr. Hudson and every other doctor that testified before you said that their testimony was to a reasonable degree of medical probability or medical certainty, depending on which doctor it was. That's the important thing. That is a doctor giving you an opinion, a medical opinion that you can rely upon as a jury. And he agreed. That's his medical opinion. Let's go to his next medical opinion. Again, this was from day 7, October 15th. Okay, in terms of Ms. Rasmussen, did she suffer a gastrointestinal injury as a result of consuming Real Water? She did. We admit that. Dr. Hudson found it as well. And Dr. Hudson reviewed all of the medical records in this case. And he found, and this is the key, all of the medical bills were reasonable, necessary, and customary. And he said that he agrees that to a reasonable degree of medical probability. As you will recall, we showed him the medical bills in this case, and he acknowledged those are the medical bills in this case. Let's go to the next slide. And by way of review, these are the medical bills of every plaintiff in this case. This is the admissible evidence as to the injuries that these people suffered because of real water and what the medical cost was to treat them for those injuries. Let's go to the next slide. This lists the remaining plaintiffs. And again, these people were very sick. There's no dispute about that. No one has ever tried to minimize that. $110,000 from Ms. Moreno. You heard Daisy Wee, you heard Sherry Rasmussen, you heard their testimony played to you in closing. These people were very sick. They had very large medical bills. Now you heard an argument about a yardstick for Blaine Jones. Let's go to the next slide, please. See if that one is. You heard argument that you should compare Blaine Jones saying, I wouldn't go through it again if you paid me $10 million, would you? And Blaine Jones said, no. He agreed. He would not go through it again. Did you see Blaine Jones' medical records? No. All you heard was argument of counsel. That's not evidence in the case. The evidence in the case is the medical costs. So when we talk about a baseline, we talk about what is the evidence of these people's injuries, we can look at the medical costs, and we can have some certainty to know that is an undisputed fact. It's not the emotional testimony of, could you torture me for $10 million? And some of these people, what they went through, they described it as torture. It was awful. There's no doubt about that. Let's go to the next slide, please. So yesterday somebody said to you basically that Real Water was asking you to be reasonable. No. The law is asking you to be reasonable. This is the jury instruction on damages. There is no definite standard. We don't have AI that can look at somebody's injuries and say, a broken arm is worth this, a liver injury is worth that. We don't have that, thankfully. We have you, ladies and gentlemen of the jury. And you're better than AI. You're more important than AI. So there's no standard for pain and suffering. The question is reasonable compensation for pain and suffering. That's not Real Water's words. That's the law. And if we put this in bold, let me say first, an opinion of an expert or a witness isn't required for reasonable compensation. That decision is yours. The argument of counsel, my argument right now, that's not evidence of what the reasonable damages are. In making an award for pain and suffering, you shall exercise your authority as the jury with calm and reasonable judgment. The damage you afflict shall be just and reasonable in light of the evidence. Remember on day one, Judge Williams pointed to the preamble of the Constitution and talked about justice. And that's what we're talking about. Justice will be your decision as to the amount of damages that these plaintiffs deserve. And we ask that you look at them individually and make an individual determination as to what those numbers should be. And we're going to give you some guidelines as to where to start, but the ultimate decision is yours. Let's go to the next slide, please. Again, Dr. Hudson, plaintiff's expert, he was asked about scarring. He was asked about what do you do about scarring? And he said, part of the future care that has been admitted to by Real Water is elastography. You've heard Hunter Brown say that he's going to go get the elastography done. Okay. Next slide, please. Elastography, it's non-invasive. It gives you a pretty good idea of where people are headed. Okay, none of the plaintiffs have had the elastography done yet, but Dr. Hudson has recommended it. Real Water has conceded that they should have it, and they should. Dr. Hudson was asked, for instance, if you continue to drink Real Water, will you continue to get damage to your liver? And let's go to the next slide. And to cut to the chase, he said, look, you take away the insult, the liver should recover. And we're going to see that at each of the plaintiffs. 20 years medical monitoring because we don't know. That's fair. We don't know what the future holds for anybody. So the medical monitoring is fair. And Dr. Hudson admits you can't tell from looking at a person how they're doing. You've got to do their tests. You've got to find out how they're doing. And you'll see later, I asked him about every single plaintiff. I didn't suggest the plaintiffs are doing well. Dr. Hudson answered the plaintiffs are doing well. Let's go to the next slide, please. All right, and again, very punchline here. Dr. Hudson testified to a reasonable degree of medical probability that all these plaintiffs have suffered permanent injuries and that this future monitoring is the treatment for those permanent injuries. Next slide, please. All right, jury instruction 21. You've got to award damages for every plaintiff. Treat them individually. Take into consideration the nature and extent and duration of their injuries, not Blaine Jones's injuries, the plaintiff's injuries. And come up with a sum of money sufficient to reasonably and fairly compensate each plaintiff for the following. Reasonably and fairly. That's not real water asking you to do that. That's the law asking you to do that. And you've seen the call of the question. And just to give you a preview, I'm going to talk about every plaintiff in order that they're going to appear on the verdict form. And we're going to talk about their past injuries, their future injuries. And you'll see, even in the jury instruction, the court has already determined the past medical expenses, and they will not be included. And for plaintiff Henry, we're going to talk about his shortened life because of getting a liver transplant. Next slide, please. So again, I know I've shown you this slide before, but it's important. Real Water has admitted it's responsible for those medical costs. Real Water has admitted it's responsible for those psychological costs. So the remaining issues are important, they're difficult. We're sorry that you have to do such a difficult task, but you've got to come up with a number. So next slide, please. So what we've done, and this is a preview of how we're going to talk about every single plaintiff in this case, is we've given you suggested numbers, and I'll talk about those in a minute, what they mean, and the past medical costs of each plaintiff. Now, sometimes the past medical costs reflect, their pain and suffering, and so, to some degree. Some people argue that there's a multiple or something like that. That's not the case of Trevor Abley. We acknowledge that. There's no mathematical formula for what Trevor Abley went through. Fortunately, he recovered. He had a pretty bad third grade, a pretty bad fourth grade. Fortunately, now he is going to be a senior, and he is playing hockey at a very high competitive level. He's currently in Boston. So what we came up with is $1 million, and we put $500,000 for each category. You don't have to do that. You could come up with different numbers, but we think the number should add up to about $1 million. It doesn't have a good comparison to his medical bills, but what he went through, what his family went through, we think $1 million is appropriate. And I think one of the witnesses said, I think it might have been his mother, thank God he recovered. And yeah, we agree. Can we see the next slide? So Dr. Lynn testified on Friday that Trevor appears to be doing quite well. His INR, his AST, ALT, they're all normal in the lab work. There's no signs of a big spleen or big liver. His injuries were in 2016, we're in 2024. That gives us at least some comfort that it's been 8 years since then. And he hasn't had any problems. We're going to say he's not going to have problems in the future? No, that's why there's medical monitoring. But he's doing well. He's being scouted for college scholarships to Michigan. I think he said Brown, Harvard, Boston. He's doing well. And I'm sure the plaintiffs would say, well, no thanks to Real Water, and we agree. He shouldn't have been sick. But thank goodness he's doing well. All right, let's go to the next slide, please. Monica Branch-Noto. Okay. Past physical and mental pain and suffering, future physical pain and suffering, anguish. Again, we came up with $1 million. The number that you decide to come up with is up to you. You can allocate it any way you decide. You can put more for what she went through. You heard her testimony. You can put more for her future. Really, the number ultimately is a jury decision. We think $1 million with the $74,000 of past medical bills is a reasonable number. I think the plaintiffs universally argued for something in excess of $10 million per plaintiff, and that would be somewhere north, when you add Mr. Henry into it, of $200 million. Our number, when you add it all up, and again, I like to skip to the end of the movie, is about $20 million. So Real Water believes these people were seriously injured, and Real Water believes they deserve reasonable compensation. So whatever number you come up with for Ms. Branch-Noto, you heard what she went through. It was awful. The vomiting, absolutely terrible. We empathize with her. We sympathize with her. As a jury, it's difficult to come up with a number, but we think $1 million cumulative is a good number. Ultimately, though, it's your decision. You'll come up with a number. Let's look to the next plaintiff, please. Hunter Brown. Mr. Brown, thankfully, was not as sick as some of the other plaintiffs. Let me say something about that. I don't think, well, it's not appropriate to compare one person's injury with another person's injury. You can't look at Blaine Jones' injury and Hunter Brown's injury. You can't look at Hunter Brown's injury and Trevor Abley's injury or Taquante Henry's injury. Every plaintiff is unique. Every plaintiff deserves the respect of having their injuries looked at, and really that's what it is. It's respect for the testimony, for the bravery in them coming here and telling you about their injuries. And we think $500,000, which is about 5 times his medical bills, is appropriate, however that is allocated. Let's go to the next slide, please. And again, these are in the order they're going to appear on the verdict form. So that's why you'll see we're going to get off on our numbering. But, you know, question 1, question 2, and then the letters is where it's going to get off. But it's D for Pamela Brown. Her medical costs were about $50,000. We think $200,000, 4 times her medical bills, is a reasonable number for what she went through. Does that excuse what she went through? No. Does that minimize what she went through? No. What she went through was terrible. Next slide, please. Now, Taquante Henry is different. Taquante Henry had a liver transplant. Taquante's past medical bills we'll see on the next page, but let's not go there yet. Past physical and mental pain, suffering, anguish, disability, disfigurement, permanent injury, loss of enjoyment of life, $2 million. Future physical pain, mental suffering, anguish, disability, loss of enjoyment of life, $2 million. Again, that's $4 million total. Allocate it how you see fit. Loss of life expectancy. I want to comment a little bit about this. So, Taquante Henry has had a liver transplant. Real Water put him in that position. It's not fair. But the ultimate decision as to how Taquante Henry is going to live his life is up to Taquante Henry. You heard Dr. Hudson talk about things that he had recommended for liver patients, regardless of whether they had a transplant or not. I think somebody called it a special diet. It's not a special diet. It's the same diet we should all do. Exercise, eat right, avoid alcohol. And that's the same for Mr. Henry. Let's go to the next slide, please. His past medical bills were $1 million, just over. His undisputed future medical costs. This is Dr. Hudson. This is what Dr. Hudson said he needs. This will not be on the jury verdict form. This will be added by the court after, are $900,000. These are stipulated numbers. Real Water agrees that it is responsible for that $1.9 million. The hard part is for you, ladies and gentlemen, to come up with the prior numbers, the pain and suffering in the past, the pain and suffering in the future, and his loss of possible loss of enjoyment of life and shortened life expectancy. The shortened life expectancy, you've heard, well, hopefully you heard Dr. Alsina. Again, we apologize for the terrible connection, but he's had liver transplant patients do very well and live for many years. Life expectancy is a statistic. We all have that statistic hanging over our heads. How we choose to live our life is what's important. Next slide, please. Adirita. He was very sick. You heard his girlfriend come in and testify. We'll talk about her damages in a minute. It was not pleasant what they went through. They were sick in the fall of 2020. $500,000 is the number we have. His past medical costs were $229,000. So we have about double his medical costs. There's no science to this. It's not a mathematical formula. AI can't do it. You, ladies and gentlemen, the jury will do it. And you'll see Mr. Ida is item F of number 1, and if you're paying close attention, you'll see we'll get off on the letters because he doesn't have future damages that we're going to talk about. Let's go to the next one, please. Mr. Link, his past medical costs were $182,000. Again, Real Water is suggesting a cumulative verdict of $1 million. 5 times his medical costs. What he went through, again, he described it. He's a very nice man. He came up and testified and told you what he went through. Weigh his testimony and come up with a reasonable number for him. And that's what the law requires. Next one, please. Ray Maynard, our UFC fighter. Thankfully, I spelled his name right this time. Apologize for that again. Mr. Maynard, what he went through, he testified to it. He was sick. He went to the hospital. He checked himself out. Fortunately, he got better. And then when he came back to Las Vegas, he drank the water and he got sick again. $500,000 seems reasonable. His medical costs were $72,000. So we're talking about 5 times his medical costs as a reasonable award. Whether you do $250,000 for past, $250,000 for future, that's your decision. He lost earnings. You heard him testify that he lost the fight. And he doesn't believe he would have lost that fight but for drinking real water. And he has agreed that he lost $95,000 in earnings. And that will not appear on the jury verdict. It's important information for you to have. Because again, Real Water has conceded that is a reasonable damage. We didn't bring in, I guess we're kind of sorry we didn't bring a UFC expert in. We might have had some interesting testimony, but we didn't need one. We agree those are his damages. Next slide, please. Carla Moreno, you heard what she went through being sick in the hospital, same time as COVID, same time as Mr. Ita. It was terrible. Again, $1 million. Her medical costs are $110,000. Is there a straight mathematical line between the two? No, there's not. 10 times roughly. Yeah, what she went through was terrible. And $1 million, whether you do it 500,000 and 500,000 or whatever formula, is a reasonable number to consider. The ultimate number you're going to decide on. Next one, please. Lorenzo Muntz. Okay, Mr. Muntz was flown to UCLA. You heard what he went through. You heard the encephalopathy. You heard how alarming it was. You heard that it was disturbing to him to be feeling out of body. And you heard Dr. Hudson, or I'm sorry, you heard that parties have agreed on counseling for that. And the dollar amount of that will be added to the verdict. And that dollar amount came from Dr. Sands for the plaintiffs. So $1 million for Mr. Muntz is what we would recommend. Next one, please. Sherry Rasmussen. Ms. Rasmussen had gastrointestinal issues that were terrible. You heard about the vomiting. You heard about what she went through. We put, her medical costs were about $500,000. We put $2 million down, 4 times. Again, there's no mathematical formula. You know, yesterday you heard talk about Blaine Jones being a baseline. That's not fair to Ms. Rasmussen for what she went through. What's fair is to look at her injuries and look at her testimony, how she bravely took the stand and told you about those injuries and come up with a dollar amount. Next slide, please. Daniel Taylor, $1 million. His medical costs were $200,000. You heard his testimony. You heard his fear about having to say goodbye to his children. It's terrible. There's no justification that we would ever offer for that. It's terrible that we make you put a dollar amount to that, but that's the way our system of justice works, and $1 million is a reasonable number for those injuries. Next slide, please. Stephen Watkins. Mr. Watkins testified. He had medical costs of about $95,000. We're suggesting $500,000 cumulative. What he went through, you heard his testimony. And you heard his testimony that fortunately he stopped drinking real water. We think $500,000 is a number to consider when you have a baseline of $95,000 for the past medical costs. Next one, please. Daisy Wee, $413,000 in medical costs. You heard her testimony. $2 million is the number we would suggest for Daisy. We would have allocated $1 million for past, $1 million for future, however you allocate it. What she went through, again, there's nothing that an attorney for Real Water can say to justify what these people went through, other than, personally, we're sorry. It's terrible. Next one, please. Brandy Wen. She was the last one to testify. She's the last one that appears on the jury verdict. I think that's a coincidence. $500,000. So let's go to the next slide. All right. Real Water question, Dr. Hudson. Real Water asked Dr. Hudson about every plaintiff that we just went over and how they're doing. This wasn't Real Water saying they're doing fine. This was Dr. Hudson as to how he believes every single plaintiff in this case. Well, he didn't testify as to all of them. Some of them he hadn't met. He testified as to every plaintiff he had met and how they're doing. So let's see what he said. Next slide, please. So he talked first about elastography and why he recommends it and the cost of it and the Real Water's response. Next slide, please. All right, we talked about Trevor Abley. We asked him, okay, he's got scouts looking at him for hockey for Michigan, Harvard, Boston, and the other one was Brown, I believe. And so far, he's doing well. Would you agree? Not Real Water's testimony, Dr. Hudson's testimony. I agree. Next one, please. Dr. Hudson, Hunter Brown, and Pamela Brown. We didn't ask him about Mr. Ita. We asked him about Hunter Brown first, and then we asked him about Pamela Brown. He got to talk to her, and we asked him, how are the Browns doing? They're doing well. Next slide, please. Mr. Henry. We got a chance to meet Mr. Henry. How is Mr. Henry doing? This is Dr. Hudson's testimony. He's doing well, thank goodness. We talked about what is it being a good steward of your liver, his new liver. You take care of your body, you take care of the liver for the rest of your life, and you don't do things that could injure the liver. That's not a special diet. It's the same diet that anybody should be on. You do things that are not going to injure your body. Next slide, please. So, we asked the interesting question, you know, if you're their primary doctor, Dr. Hudson, would you recommend any of them consume alcohol? And he said, no. It's controversial. Well, the recent literature says a glass of wine is no longer healthful. Don't drink alcohol. That's not a special diet. That's a doctor's recommendation. It's really becoming no different than doctors recommending not to smoke. Next diet, or next slide, please. And again, he says that would be true of all the plaintiffs. Don't drink alcohol. Next slide, please. Ms. Moreno, how's she doing? Good. Did you meet Mr. Muntz? No. What about Mr. Taylor? Did you meet him? No. So obviously he didn't meet everybody. We didn't feel it's fair to ask him if he didn't meet somebody how they're doing. Next slide, please. He met Ms. Rasmussen. She's doing well. What about Mr. Watkins? Did you meet him? No. Next slide, please. Ms. Wee and Ms. Wren. Met them. He met Ms. Wee in person. How's she doing? She's doing well. How about Brandy Wen? Yes, she's doing well. Next slide, please. So, the testimony and the evidence that you heard from Dr. Hudson was about the condition of the plaintiffs. Dr. Hudson, not Real Water, not Real Water's attorneys, not the attorneys for anybody in this case, gave you that testimony. Let's talk a little bit about punitive damages. You heard about the clear and convincing evidence standard. You heard about malice, fraud, oppression, conscious disregard. Next slide, please. Jury instruction 26. You heard about clear and convincing evidence, proof which persuades you the truth of the contentions is highly likely. That's for the jury to determine. You heard the testimony. You heard Dr. Hutt. You heard Mr. Desitel, who ran a production line. You heard from other Real Water employees. You heard that Real Water had about 30 employees, so people wearing different hats and doing different jobs shouldn't be that surprising. Next slide, please. So we've conceded from the start of this case that real water was not tested for hydrazine. Real water was tested. It was tested weekly, quarterly, yearly, and a comprehensive test every 4 years. Would any of those tests find hydrazine? No, they wouldn't, because that's not what the bottled water industry tests for. Next slide, please. Charles Neslin from Eurofins Laboratory, the laboratory that found the hydrazine in the drinkable water in 2023. Is hydrazine an analyte that is typically tested in standard bottled water testing? To my knowledge, no, it's not. Is hydrazine something tested for in any sort of standard water testing that you're aware of, for municipality, or municipal water, or anything like that? To my knowledge, no, it's not. In fact, Eurofins had developed a special protocol to find the hydrazine. Yes, that's true. Next slide, please. So, you heard from Dr. Najim how the hydrazine possibly was created. He didn't give you a definite answer. You heard how Blaine Jones got sick, got better, drank the water. You heard how other plaintiffs got sick, got better, drank the water, got sick again. You heard how Blaine Jones didn't believe it was the water, even when confronted by Mr. Randolph. And you've been asked to check a box as a final jury question as to whether or not you make a finding of punitive damages. And you make that finding by clear and convincing evidence. We ask that you do what the law has instructed you to do, review the evidence, and make that decision, and your decision will be fair and just. Ladies and gentlemen of the jury, thank you so much. We really appreciate, on behalf of everybody, that you came to jury duty, that you served for, what are we on, nearly 2 weeks? We're over 2 weeks. You took that much time out of your life, and we appreciate that, regardless of the types of the case. The attorneys in the court appreciates that, so thank you very much.
Thank you, sir. Okay, Mr. Kemp.
Good morning, ladies and gentlemen. I will be about 5 minutes. Mr. Parker will probably be longer, but I will be about 5 minutes. And thank you again for all your attention. And I want to tell you, first of all, I'm privileged to represent these clients. You know, yesterday I wasn't feeling too great, and they brought me enough cough medicine and stuff to open my own drugstore, so I'm feeling a little better today. 3 quick points. First of all, Mr. O'Dew has completely missed the big picture here in determining appropriate compensation. He says, everybody's fine, everybody's fine. That's not what his expert testified to. I'd like to put it up for you, but we don't have the transcript, so I'm going to read to you. I guess we do have a transcript. Nick of time. Okay. So this is Dr. Alcino. Remember yesterday it was kind of choppy. All right, where is this, just this 1 second. Okay. This is Mr. Parker's question. Well, maybe this is Mr. O'Dew's question. I think this is no, this is Mr. Parker. Okay, he's talking about the fact that when we had Dr. Robin on yesterday, again, Dr. Robin was the pathologist, Dr. Robin admitted that everybody's liver damage suffers permanent injury. Permanent injury, okay? They are more, because they have a problem with their liver, they have the fibrosis built up, they're more susceptible to injury in the future. So he asked Mr. Alcino this direct question. You could say that each one of these plaintiffs is more susceptible to liver injuries before they were drinking water. Yes, Mr. Parker, if they have something structurally, they are. If they have the problems, and they have something structurally, and fibrosis or something that remains in the liver, then they will be more susceptible. And you know you're dealing with a potential response to new insults. The new insults would be like taking Tylenol. You take, God help us, one of the plaintiffs takes 4 or 5 Tylenol, that would be a new insult. Okay, so that will trigger a problem. So the bottom line here is these plaintiffs all have permanent injury, kind of a liver time bomb. Mr. O'Donnell doesn't want to give any compensation for that. He doesn't want to give any compensation for that. Okay, next point. I suggested a baseline using Mr. Jones's testimony. Remember, he was the one that said 10 million? And Mr. O'Donnell wants you to discard that. He wants you to discard the sworn testimony of the Vice President of Real Water and accept his argument that, oh, you should give them 100,000, 250,000, 500,000, million. So that brings to mind one of the most important things the judge has told you over and over again in this case. You're going to get jury instructions. You have to follow the instructions. The instructions are the law. So let's take a look first at Blaine Jones's testimony. You can just put up on the screen, Shane, we don't have to play it. So Helen back, 10 million bucks, okay? That is the only evidence in this case from any witness at any time as to what an acute liver failure injury adequate compensation would be. And that is evidence, okay? And that is pretty compelling evidence because it's coming from the Vice President of Real Water. So let's turn to the jury instruction, number 8. So the evidence which you are to consider in this case is the testimony of the witnesses, the testimony of Blaine Jones. He gave you the $10 million figure. Statements, arguments, and opinions of counsel, Mr. O'Donnell's opinion that you should give someone 100,000, 250,000, 500,000, that's not evidence, okay? Mr. Jones's testimony was evidence. Next. Okay, this is probably one of the most important instructions. And this is the law, and the judge has told you over and over again that you have to follow the law. And if one of the other jurors says to you, yeah, let's forget about Mr. Jones's $10 million figure, let's go with Mr. O'Donnell's $250,000 or whatever it was, because it's a nice argument. Let's do that, okay? You're violating the law, okay? The argument of counsel, Mr. O'Donnell's argument on the 100,000, 250,000, million, whatever you want, that's not evidence of reasonable compensation. That is not evidence in the case. The only evidence in the case is the figure given to you by Mr. Jones. And again, remember I suggested you use that as, try to find your own baseline. You can go up, you can go down. I just think you have to look at the evidence from a witness that actually went through the exact same thing. Can I have that up one more time? I just want to put the instruction number 22. It's 22. So, his opinion, remember I didn't give you my opinion as to what the valuation would be. I gave you Blaine Jones's testimony. Mr. O'Donnell gave you his opinion. So, when you get back there, I would just ask you to consider the evidence. You've got to follow the law. The judge told you you have to follow the law. And again, thank you very much.
Thank you, sir. Mr. Parker.
Yes, Your Honor. Good morning, good morning. I want to start off where Mr. Kemp left off, okay? And I do this just because I want to make sure from this point forward, we're all on the same page in terms of these numbers and what has been suggested by Real Water. And it appears to me, and certainly Mr. Kemp is correct, this jury is required to use the evidence to make its determination. And that's what we're asking you to do. In terms of Mr. O'Douls' argument and the numbers he suggested, he kept saying to you, use the medical bills as a baseline. Not the evidence in terms of what Mr. Blaine Jones said, but the evidence in terms of the medical records as the baseline. Now, I've always struggled with that concept, this concept that the medical records is a reflection of how harmed a person has been. And it always comes to mind this example. It's relatively inexpensive to amputate an arm or a leg. Relatively inexpensive. But is the loss of an arm or leg defined by the cost of the removal? Let's say an arm or leg costs you $20,000 to remove. Is that a proper reflection of how the loss of that limb would be for that person? The rest of your life without a leg, or the rest of your life without an arm? Is that a proper way, is that a baseline for determining just how harmed a person is because you looked at their medical bills? That makes no sense, in my opinion. To lose an arm or a leg, if the medical bills were $10,000, that's not a reflection of how your life will be in the future without that arm or leg. Who would give $10,000, take $10,000 to give them their arm or leg? No one. No one would do that. And that's why that argument, in my opinion, makes no sense. And so that's why I believe what Mr. Kemp said in terms of the evidence. You consider what someone who's been through it has to say at least. And that person, his hospitalization was a couple of days compared to weeks and repeated visits and admissions to the hospital that our plaintiffs went through. So I want that I want you to think about that when you're in deliberations. What I also want you to think about in terms of arguments versus evidence, Mr. Dool and Mr. Kaufman and Mr. Freeman, they have said repeatedly to these plaintiffs when they've gotten to the stand, I'm sorry for what your order put you through. I heard that over and over again, and I was thinking about this last night. And I said to myself, you know, it's amazing that they're so sorry for Real Water, what Real Water did to our clients. Did you guys ever see a Real Water person here in this trial? A single Real Water person here? Blaine Jones, Brett Jones, Amy Jones, any of them? Not a single owner of Real Water took this stand and said that they were sorry for what they did to these plaintiffs. Not one. And listen, this case isn't about Mr. O'Doul. It's not about Mr. Kaufman. It's not about Mr. Freeman. They didn't put the hydrazine in the water. They didn't create this company. So I'm not saying shoot the messenger here. But at the end of the day, you will be the messenger. You're going to send a message to Real Water. Because they didn't show up. They didn't take responsibility. And that's another thing that confuses me. Mr. Dool has said today, and almost every time a plaintiff has gotten up, these are your medical bills, and Real Water takes responsibility for those. You heard that several times. With that 15 plaintiffs. Real Water hasn't paid a single penny, not a nickel or a dime, for any of their medical bills. They have collectively, they have well over $2 million in medical bills, and not a penny has been paid by them. I don't call that taking responsibility. I don't call that being accountable. I don't call that being sorry. That's what these people have gone through. That's the medical bills that Mr. Dool wanted to show you, that they've not paid a single penny towards. So when I hear repeatedly that Real Water is taking responsibility, they've taken no responsibility. None. Another thing I would like this jury to consider, and I've wrestled with this as well. Mr. O'Doul said earlier today, and I think he brought it up earlier in this trial, that Mr. Marlowe and Mr. Blaine Jones, of course, drank real water. Then I think he said a little while ago, even after getting sick, he drank real water. You heard that? Now, I believe he's saying that to you because he wants you to believe that real water thought that the water wasn't dangerous or effective. Consider this. Consider this, ladies and gentlemen. A drunk driver. Drunk driver gets in the car drunk. He puts himself at harm's risk, correct? He has a chance, an opportunity getting behind the wheel, having had alcohol, to perhaps have an accident and injure himself, maybe even kill himself. And that's fine if Mr. Marlowe wants to play Russian roulette with his health. That's on him. That's okay if Mr. Blaine Jones wants to play Russian roulette with his health. But does that give him the right to play that same Russian roulette with these plaintiffs, with their customers, with the public? Just because you're foolish enough to drink and drive doesn't mean you should put the safety of everyone else on the road at risk. So that argument never works to me. I cannot understand for the life of me how you can use that as some form of defense to your reckless disregard for the health of these plaintiffs. Just because you're stupid enough to drink water that you've not tested, not done any investigations after hearing about people getting sick, not even telling your customers, listen, by the way, we've had 25 people get sick. We don't know what's going on, but perhaps consider that as you drink this water. They kept it secret. They never told anyone. They didn't tell its plaintiffs, they didn't tell the customers, they didn't tell the public. And when asked by their own people to do a recall or to stop production, flat out no. That's what we know about this case. That's the evidence in this case. Shane, can you go to slide 3, please? I want to go over this just, again, to show you just how indifferent real water was to these people, these customers, and how they acted towards the FDA, the Southern Nevada Health District, and the CDC when they came knocking. So this is the establishment inspection report. This is an admitted exhibit in this case. You can look at it for yourself. And this is one of their locations, the Mesa, Arizona location. You can see the date 3/22/21 and the end date 4/7/21. And keep in mind, this investigation started 3/16/21 overall. This is when they went over to their Mesa location. The FDA went there. Next slide. So Mr. Your Honor, can I from?
You may.
Thank you. Mr. O'Doul said that this was a family company. Fine. Now I want you to understand the type of family business this is. According to Brent A. Jones, president, the firm was established in 1998 or 1999 under the name AffinityLifestyle.com, DBA Real Water. The firm changed the name of their business to Real Water Inc. on 1/1/2018. Per the Wyoming Secretary of State, the firm was domesticated in the state of Wyoming 2/28/2020. The firm was previously located at 328 West Desert Inn as the address. The firm split in September 20 and opened the Mesa facility. Per the Arizona Corporation Commission, the firm filed a foreign corporation in the state of Arizona 9/10/2020. The firm has a parent company, which is a holding company named AffinityLifestyle.com Inc. The firm has a second manufacturing facility of Real Water located in Henderson, Nevada. This isn't some mom and pop shop. This is a very sophisticated group with a holding company, filed out of state, foreign domestication. That's what we're looking at. Next slide, Shane. So now, ladies and gentlemen, at this establishment inspection conducted by the FDA, it says here, Mr. Lawrence Brown explained, and you'll see here, he's a production manager. According to Mr. Brown, the firm does not provide training on food hygiene and food safety to its employees. Mr. O'Doul said, trying to suggest that punitive damages are not in order, that they've done everything they should do. They had testing, they had some form of a plan, but this is what the FDA found. It says, therefore, do not maintain records of training. They don't have a plan, and they have no records of such. Mr. Brown also stated he did not have knowledge of Food Safety Modernization Act or current good manufacturing practice or hazard analysis and risk-based preventative controls for human foods. This is the FDA, and this is their own employee telling the FDA they've not met any of the requirements. And yet that's exactly the opposite of what Mr. O'Doul just told you. He says, as such, we determine the facility does not have anyone that has completed training in preventative controls or is otherwise qualified through job experience to develop and apply a food safety system that will be in compliance with regulatory requirements. That's completely opposite to what Mr. O'Doul just told you. Mr. Brown has had no knowledge of regulatory requirements outlined in 21 CFR 129, processing and bottling of bottled drinking water. And that's their production. You don't have to take it from me, you don't have to take it from Mr. Kemp. That's what their employee, their production manager, Real Water's production manager, told the FDA. Next slide. We explained to Mr. Brown that under the bottled water regulation, the firm was also responsible for taking and analyzing bottled drinking water for bacteriological testing, specifically coliforms at least once a week and chemical, physical, radiological tests at least annually. And we were not provided documents showing that sampling and testing was done. That's completely opposite to what Mr. O'Doul just said. And yet, Mr. O'Doul would suggest to you that punitive damages are not in order. Next slide. The firm does not have an individual trained in food safety preventative controls was discussed. This means the firm doesn't have a preventative controls qualified person. So yesterday I showed you that Patricia Converse was a receptionist, turned quality control. Mr. Desitel didn't know he was supposed to be the quality control person because he was told never to stop the line. This is coming straight from the FDA. Next. So here we move to their inspection of the Henderson location. The first group was Mesa, Arizona. This is Henderson, Nevada. And as we get back to the same date we talked about, first date, 3/16/21. And CORE is the group that's actually assigned this responsibility within the FDA. You can see here, US FDA. Again, these exhibits will be available to you on a laptop that we provide for the jury. When I say we, I'm talking about all of the attorneys here, both sides. And it says, CORE requested the collection of water samples, information and records that correspond to alkaline water manufactured and bottled from March 2020 to the present. That's what they requested. Next slide. And this is the response from Real Water. The water is filtered, they tell you how it's made, be it through the reverse osmosis, the entire way of them making it, with the exception of, you don't see it here, the Russian titanium tubes. You don't see that anywhere in that description because they didn't tell the FDA. They never told the FDA about the Russian titanium tubes in the electrolysis process. And keep that in your mind. You're going to see why it becomes even more important in a few slides. Records requested on the first day. This is another thing I want you to consider in terms of punitive damages. This firm, this company, Real Water, showed no remorse, no concern with the public even after these 5 babies were sent. Because this is all coming on the heels of that. Listen to this. Records were requested for the first day of the inspection on 3/16/21, but not immediately provided. By the second day of the inspection, the Vice President said all records requests would have to go through his attorney. Now, if you're concerned about the public, if you're concerned about the health of customers, you don't hold back your records. These records should be just provided because you want to find an answer. You want to figure out why people are getting sick. But that's not what they do. Next. I'm not going to spend much time here. I showed you this in the beginning. These are the 9 issues, the first broad categories of problems. The ones I've highlighted, and you'll be able to pull this up, they have no written food safety. They didn't identify foreseeable hazards. Listen, if you got a new process, you test before you start putting it on the market. Did not sample, test cleaning, sanitizing solutions as often as necessary to assure adequate performance. Did not take and analyze samples of bottled drinking water for bacteriological testing. That's number 9, which is exactly the opposite of what Mr. Perdue just said. Next slide, sir. We just showed you 9 issues. Let me show you how that breaks down in terms of all the issues. The Vice President promised correction of all 483 observations and said he would respond in writing. Ultimately, 483 deficiencies. We gave you the 9 categories, but that's how bad that firm was. That's how bad Real Water was. Next slide. And let me show you some defiance. A complete defiance by Mr. Blaine Jones. An inspection attempt was made on 3/18/21. The Vice President, Blaine Jones, did not arrive at the previously scheduled time of 12 noon. And the facility doors were locked, so no facility inspection was conducted on that day. If you are trying to figure out what is going on, you don't stand up the FDA. That's not what you would do. If you actually care about the health of people, you don't do this. Next slide. As of 3/15/21, this is the day before the inspection, Core reported there were 5 cases of acute liver failure with unknown etiology. Those are the 5 children. Onset date ranges from 11/8/20 to 11/29/2020, with the ages ranging from 7 months to 5 years. And we saw that in the MMWR report. 3 of the 4 outbreaks families specifically reported receiving Real Water. So there's no dispute that they knew the problem, and there's no dispute, knowing the problem, they chose not to do any testing, not to do any investigations, and this is how they treated the FDA. Next. From October 15th, 2020 to November 15th, 2020, Manager Anthony Brown received 25 to 30 customer complaints of odd tasting water. Mr. Brown stated that 7 to 8 of these complaining customers also reported harm. So in addition, even before the children became an issue, they knew this in October. And Blaine knew it from himself on October 5th. That's when he got sick. Let's go to the next paragraph. It says, on April 7, 2021, Anthony Brown provided 5-gallon delivery account terminations for Nevada, California, and Arizona, in which the customers claimed medical reasons for canceling their water. You're getting 20 to 25 customer complaints, and eventually you're getting 23 account terminations because of medical reasons. Somewhere between 53 terminations and sicknesses that you're aware of, and you do nothing. Not one thing. Blaine stated the firm received numerous customer complaints around November, reporting an off taste and nausea. And the evidence in this case is clear. Despite receiving all of this, not one test, not one investigation. Just free water. Next. This heading here, refusals. FDA in the core report, you'll see that if you want to when you're in the back deliberating. Exhibit 3, so you can see the full core report, and you'll see the list of refusals by Real Water saying they're not going to cooperate. So this one says the second section is where the mixing of concentrate takes place. Now, I told you this would come back up. They never told the FDA about the titanium tubes. They also did not show, I'm using Mr. Kemp's words, the secret room. They never told them about the secret room where that concentrate was made. So this is when it comes to light. During the initial walkthrough, Blaine Jones told us the processing area consisted of only the main bottling area. He did not tell us that the adjacent section was part of the production, and this section was not included in the diagram provided to the Southern Nevada Health District in the company permit application, although it was included in the lease. So the lease shows the streets, but when they applied at the Southern Nevada Health District, they didn't even tell them about that secret room, and they didn't tell the FDA. The FDA found it during the inspection. That's how little concern and regard that Real Water had for these people, for the public, for their customers. They hid the space, they hid the technique, because they thought that that's what was going to make and generate their money. And they didn't want the FDA, the CDC, or the Southern Nevada Health District to find it. Next slide. On the second day of the inspection, we met with Blaine Jones at 1:00 p.m. to accommodate his schedule. That's amazing to me. The FDA is accommodating his schedule. Blaine refused to answer questions about the bottled water production, and he stated all record requests would have to go through his attorney. Does that sound like a company that's sorry? Or a company that's taking accountability? That's why punitives have to be imposed. It just has to. He further says, we plan to return to complete our inspection on 3/18/21, and we scheduled a noon appointment with Blaine to accommodate his personal schedule. An inspection attempt was made, but Blaine did not arrive as previously scheduled. The facility doors were locked, so no facility inspection was conducted on that day. Garrity called Mr. Jones and left a message on his answering system informing Mr. Jones that we were at the facility for the pre-scheduled meeting and requesting a return call. No return call was received from Mr. Jones. The FDA is bending over backwards for this guy for the benefit of the public health, and that's how he's responding, or not responding. Next slide, please. Mr. Garrity requested processing records for the approximate 5-gallon bottles of alkaline water. Mr. Jones refused to provide the requested records, the processing records, stating that the processing records were lost in the move from Las Vegas to Henderson. That's the kind of excuse he believes he can use to avoid the consequences of their conduct, or misconduct, I would say. Garrity and I returned at 2 p.m. to meet Blaine Jones, scheduled through his attorney. Mr. Jones said he would not answer any of our questions, but did show us the section of the building where real water concentrate is mixed. After all of this, it finally happens 3 days into the inspection that they find a secret room where the Russian titanium tubes are held and where this mix, the concentrate is made. Next slide. Mr. Jones declined to provide any of the requested documents to the inspection team. As justification for his denial, Mr. Jones claimed 2 excuses. The firm's chemical supplier would not be able to provide any documents until Monday, and the firm's legal counsel still needs to review all the requested documents before they're released to the FDA. How can Real Water get up in front of this jury, in front of each of you, and say that they're responsible or accountable when they wouldn't be responsive to the FDA? And in fact refuse requests made by the FDA. That shows a conscious disregard for the safety and health of this public, of these plaintiffs, of their customers. Next slide, King. Mr. Jones said the firm's ionizing process was intellectual property purchased by his father, and he did not want to reveal the procedure in front of Mr. Brown. This is Blaine Jones telling the FDA that he doesn't want to show how we make the concentrate in front of his production manager. That's what he's saying. He wanted Mr. Brown present as a witness, I explained to Mr. Jones that any trade secret information provided to the FDA by his company was not releasable to the public and would be redacted from his report if any FOIA requests are made. Mr. Jones addressed Mr. Brown and said he was going to have to sign a disclosure agreement. Mr. Blaine Jones was going to force his own employee, his own production manager, to sign a non-disclosure agreement before he would reveal to the FDA how they made the concentrate. Does this sound like a company that was interested in public safety at all? The FDA's mandate was to protect the public and to figure out what was going wrong. And here Blaine Jones is saying, I'm not going to even tell you how we made it. I'm not going to show you where it's made, and I'm not going to tell you how it's made and what it's made of. And that's what he wanted. Next slide. And that's the core network cover sheet. So when you look for it, you can see this is Exhibit 2. It's a very lengthy document. It will take me 2 hours to go through it, but you'll have it at your disposal. Next slide. And these are the results that we've talked about, and it's in the report. We know that several dogs died. We know that a cat died. They found at this point 20 probable cases plus 5 suspect cases. But I wanted to show you this one. I want to read it. August 19th. These injuries were known to Real Water in August of 19. And there were 23 hospitalizations and 1 death, not including the liver transplant that we know that Quanti Henry suffered through. Just imagine if Real Water had been responsible and accountable, reasonable, and actually did stop production in August of 20. 10 of our plaintiffs got injured after August of 2020. 10 of them. 10 of the 15. But they refused to stop production. They refused to do a recall. Next slide, Shane. According to the company website, Real Water is offered in a 5-gallon home delivery format and is distributed throughout the United States. The company also states that Real Water is sold in ready-to-drink format. The firm's water is also sold to Whole Foods, Sprouts, Raley's, H-E-B, I'm not familiar with that one, Bash's, regional independent natural product retailers, and online sellers such as Amazon and Instacart. That is a tremendous amount of volume and a tremendous amount of reach. The sellers, distributors throughout the country. Next slide. And I showed you some of these earlier. I'm going to show you a couple now, ladies and gentlemen. What I wanted to point out here is this person complaining about their experience with Real Water. In November of 2020, they were admitted to the hospital, and they've been consuming it since 2017. They got sick in 2018, and went undiagnosed as a medical mystery. That's the same medical mystery that each one of these plaintiffs suffered through, not knowing, being blamed for something that they hadn't done. You know, being suggested, there was suggestions made or innuation or comments made in the medical records suggesting that maybe they drank alcohol too much. Things that had nothing to do with the real culprit, Real Water. Next slide, please. Again, a very blatant piece of evidence showing that they could not care less about the health of the public, these customers and these plaintiffs. This customer said, I emailed the company Real Water back in December 2020 letting them know that the water was making me sick, and they did not respond. Next one, Shane. This customer, similar, feeling deathly afraid for long-term effects. If it was found out in November, how come they kept selling the stuff? The answer is easy. They kept selling it because they were making money. They kept selling it because they could care less about the public safety. That's why they kept selling it. Next slide. This is Mr. O'Dou's opening. You can play that for me?
We've played you a little clip of Blaine Jones' testimony or hear more during the course of the case.
how Lane Jones took the water on his camping trip, drank the water, made him sick. He was very sick. Even after his illness, he continued to drink the water because he didn't understand the water was making him sick.
That's what I was telling you earlier. When I heard that in the opening and I thought about it last night, how can that be an excuse to these plaintiffs, to those customers, and to the public? If Blaine Jones can drink the water, be told by his vice president of distribution that it's the water that made him sick in October 2020, and he still not tell the public, not tell the FDA, not tell the CDC, Southern Nevada Health District, or send some type of alert to their customers, the only way real water will be held accountable is for punitive damages. Because nothing else seems to matter. And if it did, I would expect that he would be here. He would have taken that stand. He, his father, his stepmother, they would have taken the stand. Next slide.
Every plaintiff that we injured from our product has pain and suffering damages that you will award for their past pain and suffering and for their future pain and suffering. They're going to have worry. They're going to have, some of them are going to have future doctor appointments. Some of them are going to have future treatment. Those are damages that real water caused and that you will award.
All right. Again, this is Mr. Abdul's opening. And we are asking you to do just that. But we, like Mr. Kemper said, we've tried to use the evidence to support whatever decision you make. We agree with Mr. Abdul in terms of these are the types of damages. That part is true. But reason, and that's the word that Mr. Abdul pointed to in the jury instruction, what is reasonable in terms of the damages? Mr. Abdul suggested to you that certain figures are reasonable. And then he said it's up to you, how you decide, because there's no formula. Except that every time he brought up the medical bills, he said 3 times or 5 times, as to suggest that there is some formula. What we do know came from these doctors, and both Dr. Alcina and Dr. Hudson said, given what we know about hydrazine's effect on livers, these people have permanent fibrosis that cannot recover. It won't regenerate. That's what we know. And I will tell you, $250,000 won't fix it. It just won't. Next slide, Shane.
DeQuante Henry, real water caused his injury. Real water caused him to have a liver transplant. Real water caused him pain and suffering in the past, and it's causing him pain and suffering in the future. And you heard the real water expert disagrees with the plaintiff's expert, and actually everybody wants him to have the best prognosis possible. Everybody is rooting for these people to fully recover. But the real water expert, Dr. Alcina, admits that his life expectancy is more reduced than the plaintiff's own doctor.
I said this yesterday, I think it's worth repeating. He said everybody wants them to recover. Well, we know all the plaintiffs want to recover. I don't know what everybody Mr. Abdul was speaking of. Certainly, again, we've not seen anyone from Real Water express that on the stand. There's no evidence of that. That's argument as opposed to evidence. We know they want to recover. And we also know that if you were simply to accept the evidence, there is no evidence that any of them have livers that have not been permanently damaged. Has anyone seen just a single biopsy slide that says that any of these people have no damage to their liver? None. We didn't see it from any witness on behalf of Real Water. The only slides we've seen showed injury. Every slide we looked at showed injury. Be it Loma Linda, be it the 6 plaintiffs that we have here, there was not a single slide that showed no injury. So where does that leave you? With the evidence that all of them have suffered permanent injuries. And that's it. Dr. Lynn said something, I don't know if you guys caught it, I'm sure you did, but these are things I think about overnight. Dr. Lynn said, there's one thing in terms of how I feel as a doctor, there's another thing in terms of how I feel as a parent. And he said, if I was a parent, I would be worrying about Trevor Abel. I would want to make sure he had this follow-up testing. Ladies and gentlemen, you get one chance to do this. These plaintiffs get one chance. This is their only case. They don't get to come back to another jury. They only have you. So you have this one chance to do what you believe to be right, within the bounds of these jury instructions. There's no second chance. Next slide, Shane. So this is the jury instruction we talked about yesterday. I'm not going to spend much time with it. You'll have time to read through it. We're going to provide it to you. Go to the full instruction. What I want to impress upon you a little more is that when you consider the conduct, to me, the evidence shows that this conduct has been despicable on the part of the award. The refusals to the FDA, the denials of the injury to all of the customers, the medical terminations that went uninvestigated. That's despicable conduct. In terms of the damages, again, Mr. Kemp spent a lot of time on it. I won't spend much time on it except to say that there's a separate damage for Mr. Quanti Henry. You will get a chance to look through it. You determine what you believe to be reasonable based upon the evidence in this case. In terms of punitive damage phase, there's going to be a box that says yes or no in terms of punitive damages. Again, we believe that the evidence supports squarely saying yes. The punitive damage phase, if you say yes, is very short. Typically, it's an hour and a half or less. Generally, there's only one witness that may be called, two at the most, and then there's just argument. Sometimes no witnesses are called, it's just argument of counsel. That's it. And that typically follows your determination on the compensatory damages. Okay? So I say that just to put your mind at ease. It won't be another 2 weeks of trial. You don't have to listen to Mr. Kemp go for hours, or Mr. Adu go for hours, or me go for a couple of minutes. You don't have to worry about that. It's a very short process. I saw that look. It's a very short process. Like I said, it's less than an hour and a half typically, and generally it's one or two witnesses, and that's it. And it follows right behind whatever decision comes. Compensatory, we normally do it right after that, depending on what the judge has on his plate and what you have on your plate. But normally it follows one after the other. Just so that you're not thinking it's another long, drawn-out process. The only thing else I would say, ladies and gentlemen, is if you don't award punitive damages, next slide, I want you to consider the message you're sending if you don't award punitive damages. And we're not talking about the amount, just striking the box. If you don't, you're telling...
Objection, Leosh.
Can we approach? Because I don't see this as a Leosh, valid Leosh objection.
All right, thank you, counsel. And Mr. Parker, you can proceed.
Thank you so much. Shane, can you put that back up for the jury, please? So again, ladies and gentlemen, if you were to say no to punitive damages, this is the message I believe you're sending. Number one, it's okay to create a new product, a new manufacturing process, without testing the safety of the process or the product. That's the first message you're sending. Go right ahead, Shane. In fact, you can put them all up. Thank you. It's okay not to conduct non-targeted screening tests. And this is another thing that bothered me about what Mr. Adu said a few moments ago. He said that the Eurofins gentleman, Charles Nelson, said they don't normally test for hydrogen. We know, based upon the FDA documents, the FDA came in, the first thing they did was test, and found it. They didn't use some special protocol, some special process, some modified GCMS machine. They simply used a GCMS machine and got the results. That was it. So this whole idea that it was not available, the equipment was available to test, it was an inexpensive test, they chose not to do it. The first thing the FDA did, not knowing what was in the water that was causing the illness, is they tested it, and they found it. So we're saying if you say no, then other companies will believe that they can just come up with some process that's not tested, perhaps not safe, and put it on the market. Something like water. Next, it's okay not to investigate customer complaints. Not one investigation, and now we know of at least 53 customer complaints that they could care less about. It's okay not to test the safety of a product after customers have reported health problems. So if you were to give them a buy or a pass on not testing initially, how do you allow them not to test after you have all these people reporting their sicknesses, hospitalizations, a death, children, pets? It's okay not to have a qualified QA or QC employee, quality assurance and quality control. We know from the FDA documents, they didn't have anyone qualified to do so. And they admit to it. When I say they, their former employees or employees admit to it. It's okay not to stop production when employees and customers are getting sick from consuming your products. Again, Mr. Anthony Randolph said stop, do a recall. Mr. Desatel said he would have stopped it. They never stopped it. They never did the recall. Next. Good. And then finally, it's okay to refuse to cooperate with the FDA, the CDC, and Southern Nevada Health District. If you say no to punitives, you're saying companies don't cooperate with the local and national agencies trying to figure out why people are getting sick and being hospitalized. They refuse to meet scheduled inspections. They refuse to answer questions. They refuse to reveal information regarding the secret concentration room. They withheld information regarding their product and how the concentrate is made and what's in it. And they refused document requests. That's what they did. Finally, it says the messages that will be sent if a significant punitive damage award is not made. And we'll talk about the amount if you strike the box saying yes. But you have to say yes, because otherwise you're telling companies and telling Real Water it's okay to violate the FTC Act by providing an adulterated product. It's okay to violate 21 CFR by not having good manufacturing practices. And that's what Dr. Hyde talked about. And then again, number 10 is okay not to test product that's required and failure to maintain records of testing. And we know that's what they did because the FDA requested them and they didn't have them. Is that the last one, Shane? Perfect. So ladies and gentlemen, again, I appreciate your time. I believe there's more than enough in terms of clear and convincing evidence to support striking yes in the punitive box. We do appreciate all your time, all your efforts, and your patience with this process. And on behalf of all the plaintiffs, thank you again.
All right, thank you, sir.
Thank you, Your Honor.
Let's go ahead and get it. Can you bring Lynn in and swear in the matron?
Sure.
So, ladies and gentlemen, what we're going to do, the marshals are going to come back with a judicial executive assistant who will also be sworn in, and they're the only individuals you should have contact with. And let's go ahead and
I'll start first with the bailiff. You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed. So help you God? Thank you. You do solemnly swear that you will keep these alternate jurors in some private and convenient place, that you will not permit any person to speak to them unless it is by order of this court. So help you God? I will. Thank you.
okay. And so, ladies and gentlemen of the jury, we've completed closing arguments, and now it will be time for deliberation. And the marshal will take you back to the jury deliberation room. Sir.
All rise to the door to adjourn. Jury is clear, please be seated.
Thank you. Hey, counsel, before you go, Tori stepped out for a second, but I want to make sure she gets all contact telephone numbers from you before you leave.
Thank you, Your Honor. I understand that the court has some things on calendar tomorrow. I'm just inquiring, when do we want to deal with the punitive damages instruction? Do we want to do it this afternoon, just in the event we need it, or do we want to wait and see what the jury does?
We do this afternoon if you want.
Might be efficient, whatever the court desires. I just wanted to alert the court that there's that issue.
No, I appreciate that, Mr. Chairman. What do you think, 2:30? Is that a good time?
We could do it earlier, Your Honor, because we're gonna stay downtown.
Oh, okay, you guys,
I don't know what your schedule's like.
I haven't looked yet.
Your Honor, I would just raise one issue with, we filed a bench brief on our position regarding the instruction. I'm not sure if the court has had a chance to review that yet, but it is, fairly short. That's just one thing we want to make sure the court's aware of before the argument.
All right. It's 12:30 now.
I mean, we're all gonna be back here tomorrow too, so,
We can do it at 2 o'clock.
whatever the court desires.
Yeah, that gives us a little time for lunch.
Sounds good, Your Honor.
Thank you, Your Honor.
Yeah, and that way you don't have to,
Right.
yeah, go and come back and so on and so on.
Thank you, Your Honor.
Yeah, thank you. Yeah, today's better. I'm doing it too. I don't want you to sit around waiting, so we'll have a hard 2 o'clock.
Number 16 will not come back forward. Please be seated. Thank you.
All right, let's go ahead and set forth our appearances.
Good afternoon, Your Honor. Eric Pepperman, Will Kemp, Teddy Parker, and Brianna Swissler for plaintiffs.
Good afternoon, Your Honor. Joel Ledoux, Matthew Kaufman, and Eric Freeman on behalf of the Real Water defendants.
All right, before we get started, we did have one question from the jury. And I had copies made for both sides, 2 and 2.
Interesting.
And this was from juror number 2, Marguerite Madison. Question 1, is the sum of money that we write down for each plaintiff subject to any taxes? Number 2, or part of the attorney's fees to be paid by plaintiff. Number 3, net worth of the company.
Yeah, Judge, I don't think we can answer these.
Agree with Mr. Kemp.
All right. But we have to answer them in some way. I guess the best way to say it is, look, read the jury instructions as to what they're to do.
Just in case, give the plaintiffs more.
That doesn't sound like a good idea.
So, Your Honor, the second one is the easy one. The reason why we can't do it is because of the Bon Jovi Sullivan case. That one I know.
But I know we can't do any of this.
Right. I think, because I don't like ignoring the jury, or I don't want them to feel like they're being ignored. I would just say that none of these are considerations.
And to read the jury instructions.
Yeah. The jury instructions don't touch plaintiff, tax, then talk about attorney's fees, and then talk about net worth, so.
I actually was gonna say something similar to, Mr. Parker. I think that we should tell them that 1 and 2, should not be taken into consideration.
Don't we have that? Didn't we give them that jury instruction?
Not
We didn't
on
give
taxes, not on.
We didn't give them collateral source and any of that?
No, we didn't give collateral source instruction.
Now you're looking at why.
There is no collateral source issue, Your
We
Honor.
never give
What?
There is no collateral source issue here.
We never give a collateral source instruction for taxes or attorney's fees.
Well, I understand that.
Similar.
It's similar, but don't we have that one you had to consider whether or not the defendants carry liability insurance that would compensate them and all that stuff? anyway,
The only reason why we would be concerned about pointing the jury to a specific instruction is it tends to emphasize whatever's in that instruction and may have unintended consequences. I mean, I think referring to the instructions as a whole is fine, but,
Yeah, Judge, I kind of agree with Mr. O'Donnell.
how about this? They're not to
You should follow
consider,
jury instructions and not consider other potential consequences. Is that okay?
I like that last part.
And not consider other potential consequences.
I would agree with that.
Yep, that sounds good.
so. And I always tell them, read the jury instructions. You know.
We did.
All right, I want to make sure we get this correct, so there's no error. What should we tell them?
You should follow the jury instructions and not consider other potential financial consequences.
Okay, you are to follow the jury instructions and not consider, Mr. O'Donnell? Mr. Kent, not to consider?
Other potential financial consequences.
Is that fine, Mr. O'Donnell?
Yes.
Judge, was there a time that this came in?
Probably about, what, 40 minutes ago?
Yes, Your Honor, that's about accurate.
Thank you.
You are to follow the jury instructions and not consider other potential financial consequences?
Yes.
You want to type this out, give it to them? Or just say it to them? It's up to you. whatever you want.
I don't mind. I think the sooner you give it to the better.
Right,
Yeah.
but I can have this typed out in like 30 seconds.
So that's fine, Your Honor. It's better record.
You can do it right now, and just give it to them, and that way there's no confusion.
Sounds great, John.
Do you want it in any special formatting?
Just font, regular font,
Okay, I'm making it big size.
and just print it out. And the reason why I kind of like doing that, there's no confusion. Because you can read it to them and give it to them. Is this fine, guys?
That's fine. Move.
I'll let you take a quick look and then we'll go back in there.
Yeah, that's fine, Your Honor.
Go tell them and then give it to them,
Yes, Your Honor.
because I don't want any confusion. All right. Oh, punitive damage jury instruction. Let's get started. Who's handling, Mr. Pepperman, you got it?
I was just gonna hand the court a copy of plaintiff's proposed instructions if the court didn't already have one,
You can help me.
if I may approach.
I might have it, but I'm not sure. Okay. And so there's one dispute about one sentence, is that it?
Yes, Your Honor, assuming that Mr. Peppermint had a Nevada pattern jury instruction 12.1 as modified, and item number 2, it reads in the stock instruction, the amount of punitive damages that will serve the purposes of punishment and deterrence, taking into account the defendant's financial condition. I believe the way the plaintiffs have modified it is ending the sentence at the word deterrence and removing the words taking into account the defendant's financial condition.
All right. And so, taking into account the defendant's financial condition, you feel should be included?
We do, Your Honor, and we've had this argument before in other cases, and I'll just give you a synopsis of Real Water's position. Your Honor, we believe that it's important for the jury to have some type of context if they're going to award punitive damages. The cases say what they say, and what I mean by context is this. They have proffered the testimony of Anthony Randolph about the bottled water industry being a billion-dollar industry nationwide, and that they have proffered the testimony of Mark Rich about Coca-Cola, Nestle, Pepsi, Dasani, I think some other bottled water manufacturers. And the problem with all of those is it gives the jury the impression that a constitutional punitive damages award would be something that would punish or deter Coca-Cola or Pepsi or Nestle or Fiji or Dasani or some other water gigantic company. And that, in our view, resulted in an unconstitutional jury award in the Wren case that was many times the compensatory damages award. And so the question that we just got from the jury about the net worth of the company already shows that the jury has in its mind some type of preconceived notion of a very large award. And the problem with that, again, is it doesn't bear to the evidence. It goes to the prejudice and the passions and the arguments they heard in voir dire about $1 billion judgment, the arguments they heard in trial about punishing and sending a message. We had objected to those arguments, and we continue to object to those arguments. And Your Honor, this is just another, we're removing the guardrails, if you will, on the road to a proper and constitutional verdict. And by removing those guardrails, taking out any type of financial consideration, we're inviting a verdict that is improper. It's happened before, it appears it's going to happen again. We understand.
Here's my question, what do I do? Because I think I brought this up sidebar.
You did.
What do I do when you have a defendant that's in bankruptcy?
And that's exactly the issue, Your Honor. There was an email from Brent Jones to Gray Maynard that talked about the number of bottles that Real Water sold during its lifetime. It was, I think, 65 million or something like that. Is that misleading? I don't know. I think there's a problem with that. In the Gallagher trial, we had offered testimony that Brent Jones had testified that the best year of Real Water was prior to COVID, and in their best year they had revenues, not profits, of $9 million. We believe that at least provides a ballpark for a jury to render a verdict. That issue was considered, and I know this doesn't go into the court's consideration, but I think it's interesting. That issue was considered by other judges, and the interesting thing is that they don't want to mislead the jury the other way. And so it becomes, in our view, a question of prejudice. Real Water should not, and the ultimate verdict should not be prejudiced by the fact that Real Water is in bankruptcy. It should be neutral. It shouldn't favor Real Water, and it certainly shouldn't favor the plaintiffs. And by removing this language, it favors the plaintiffs. They have been able to argue about billion-dollar bottled water industry, billion-dollar corporations. I'm sure they'll give you the exact quote from Mr. Randolph, but it's a staggering amount of money that is generated in the bottled water industry. To say that you're going to deter the bottled water industry invites an unconstitutional verdict, because Real Water was never a billion-dollar company. It wasn't even a $1 million company. At its best, they had revenues of $9 million, and towards COVID and even after COVID, they were not profitable. And you know, that evidence will never come before the jury because of the bankruptcy, and so the jury doesn't have a ballpark with which to measure what the deterrent should be for Real Water. And so then we're now deterring people who are not parties to this court. And now we do have a Philip Morris instruction, but again, we have no evidence then for the jury to consider what it would take to deter Real Water. And I guess the plaintiff's argument is there's no deterrence because Real Water's out of business. So then the question becomes, what are we trying to deter? Are we trying to deter bottled water manufacturers from using electrolysis to negatively charge water? Or are we trying to deter something that doesn't exist in these other bottled water companies? I guess, you know, some type of fictitious bad conduct that they may do in the future. And that becomes a problem as well. So we've kind of argued this pretty extensively. I'm sure the plaintiffs will fill in any blanks that I left out, but it's a problem. And we think the evidence, we think the jury needs to have evidence to render a verdict. And if we deprive them of any evidence, then we think the verdict is based on a fiction. And that fiction is, let's punish Coca-Cola for something that Real Water did.
From the plaintiff.
Your Honor, Mr. O'Doul is correct. This issue has been argued, I think this is the 4th time, and every time that it's been argued, including the first time, which was in front of Your Honor, you allowed the instruction that the plaintiffs are proposing. In Gallagher, this is the instruction that was given. In the Hunt-Watson case in front of Judge Kishner, this is the instruction that was given. In front of Judge Hardy, which is the Wren case, this is the instruction that was given. And now we're full circle back before Your Honor, and we believe that your decision in the Gallagher case was the correct decision. And I believe every other judge heard this, believed that your decision was the correct decision, because we informed them of your decision as well. And we're not, I know this court makes its own decisions, but that's the decision this court made in the Gallagher case. And it's because the bankruptcy makes the second part of this superfluous. And it also, I believe, and this is the reason why I hadn't come up in the entire presentation of this case, it has nothing to do with the beginning part of paragraph 2 of the pattern jury instruction. And we've argued throughout this case that while punishment is one part of it, deterrence has been our leading argument for reasons why punitive damages should be awarded. One thing that Mr. O'Doul said that always resonates with me, but I think there's an easy fix to it. He talks about the constitutionality of the
Well, I was thinking about that because at the end of the day, I have to follow the mandate under State Farm.
Bingo! And you are the guardrails. You are the judicial
I mean,
guardrails.
I think about that because State Farm, I think, what was it, 10 to 1, the outer limits?
Mr. Kemp has given me hope that there's a chance it's maybe up to 12 to 1, 13 to 1. I've been pushing it since we've been doing these cases. He said there's a chance of 20 to 1. I'm still working on it. But 10 to 12, Your Honor.
Well, I mean, it's
is
my
something that's been
recollection, Mr. Kemp
discussed.
probably remembers this a little better than I did, when I did the reduction in the hepatitis C case, it was over 10 to 1. It
Yeah.
was maybe 11 to 1, but it was over 10 to 1. That's my recollection. Is that true, Mr. Kemp?
I think slightly over.
Slightly over, but it was over. And I can't remember why I did what I did, but I gave a reason why I went that high, because of the, you know, I didn't want to, because I think State Farm was a little bit newer then, and I didn't want to go too far, but I think it was, my calculation was actually made sense what I did,
Absolutely, Your Honor.
you know.
Remember, there were 2 defendants in that case, Your Honor.
Yeah.
Punitive, so.
Yeah, but I remember something like that, and see, here's the thing. I mean, I talked about a sidebar.
You did.
Before it was even teed up.
You previewed it before we even got before the court to formally argue this, Your Honor.
Right.
And it's funny, you actually, when you brought it to the attorneys at the sidebar, it refreshed at least my recollection of that coming up in front of the other judges. Because each, I believe, Judge Hardy said it, or addressed it head on. He said, why should you be able to use bankruptcy as a way of avoiding responsibility? If that's the case, then they'll just, every time a case is filed that has a punitive damage potential to it, they just file bankruptcy. You shouldn't be able
And understand me, I hadn't talked to Judge Hardy, but that's the first thing I thought about.
You did?
And I mentioned that sidebar.
And we had a lengthy oral argument on this in front of both Judge Kishner and Judge Hardy, Your Honor, and ultimately they went in the same direction that you did in terms of this instruction. And looking at the Ace Trucking cases, the case we mentioned in our briefing, Your Honor, we believe that this is the appropriate instruction. Bankruptcy takes out of consideration the last part of the sentence, and I think the court should remain consistent with its previous decision, Your Honor.
Mr. O'Doul, you get the last word on it.
Thank you, Your Honor. I think there's two problems with that. One is, and just to finish that argument, is, and I'm going to raise a second argument, so if Mr. Parker needs to respond to the second argument, that's fine. But the problem with that decision is we're still inviting an unconstitutional award and then counting on this court to correct it afterwards. And it also, that argument ignores the fact that there's no evidence as to what amount would deter. And so there's an absence of evidence. In the bankruptcy field, we have to keep it even. We can't favor the plaintiff, we can't favor the defendant. An absence of evidence favors the plaintiff. The second thing that Mr. Parker has not had an opportunity to respond to, and I think he should, is the testimony that's being offered. And we object to the testimony that's being offered. And certainly I'm not trying to throw an apple in with the oranges, but I think we can dispose of all the issues together. They would like, I believe, Mr. Rich to testify something along the lines of, you know, the award of $2 billion would be less than 1% of Coca-Cola's estimated $253 billion market cap, less than Pepsi, so forth and so forth. And again, the problem is you're deterring conglomerates that are multinational conglomerates in the billions of dollars. They've proffered the testimony, and we believe that testimony should be inadmissible. They've proffered the testimony of the VP of Sales, Anthony Randolph, who talks about the bottled water industry to be in 2011, $21.7 billion, according to work done in Bradstreet. Global market revenues of approximately $330 billion, and so forth. And these numbers are mind-bogglingly large and have nothing to do with deterrence in a personal injury case. These are numbers that are outside the state of Nevada. We have an instruction that the parties have agreed upon, the Philip Morris instruction, but we think the evidence in and of itself is objectionable because it invites an unconstitutional verdict. So Mr. Parker didn't get a chance to respond to that, or didn't get a chance to address that, so I certainly would yield the floor to him.
No, I appreciate that. Your Honor, the first thing I wanted to mention, and perhaps Mr. O'Doul may want to stand back up and address this, but our state statute involving punitive damages and when they're appropriate, what the limitations are, there are limitations on certain 3-to-1 types of claims, but not on the product liability cases. There is no statutory limitation set by our legislature. So in terms of the constitutionality issue, again, there's judicial restraints on those, but statutorily, Your Honor, there are no limitations on punitive damages in this type of case. So I want the court to be, I'm sure the court is mindful of it anyway, but I want to make sure we put that on the record. And I do appreciate Mr. O'Doul ceding the floor to me in terms of the amount. What we did in the Wren case, Your Honor, which is similar to what we did, we intended to do here, but because of the bankruptcy and because of the jury not striking the box against the meter companies, we didn't need this testimony at the time. But, Your Honor, what we did in Wren is we put in front of the jury and in front of our expert, based upon his report, the bottled water industry. We didn't put in front of the jury all of the money that Coca-Cola or Pepsi makes. We actually separated that to only the bottled water industry. And we used that portion of that industry to come up with a total number in terms of what the annual value of that industry was. And in 2022, Your Honor, that number was $85 billion. We asked for a fraction of that amount from the jury. In fact, we asked for 1.7. Mr. Kemp told me to tone down the number, actually, and the jury ended up giving us $3 billion. So they gave us more than we asked, which was still less than 1 or 2% of the overall number. So, Your Honor, we tempered the number, thanks to Mr. Kemp. We tempered the number, and the jury gave us more than we asked, but it was based on a subset of the bottling industry only to water. And these are the people that the statute, in our opinion, and this jury instruction is aimed at deterring. Because the next new bottled fangled water or process should be tempered by a decision like this. And that's the point of if the jury strikes the box, that would be the point of their number. And I appreciate that, Joel. I know I brought up something new that you may want to address.
No, I appreciate that.
But that's what the statutory thing you do, so you have every right to address that. And then, if you want to look at the transcript, I can show it to you just in case.
No, I have it and I recall it. Thank you very much. Yeah. We did talk about the statutory limitations in Nevada, and again, we believe that's why there's constitutional limits on awards in Nevada. To just kind of sum up the position, the cases also talk about a shock to the consciousness of award, and that's really, I guess, the final point we would make. If you're talking about an $85 billion industry as a hypothetical, we use that number. At best, Real Water had revenues of $9 million, and so you're seeking to deter or punish a company that would be of equal size and has revenues of $9 million by giving them a $3 billion verdict. I mean, it's frankly the equivalent of the death penalty for jaywalking. The numbers don't make sense. $1 billion, $3 billion, those are mind-numbing numbers that when you're talking about a $9 million company don't make sense. It's not the right ballpark. Certainly, if you've got a $9 million company, I think what was the punitive damages verdict in the first case? 200 million? 200. I mean, we thought 200 million in the Gallagher case for a $9 million company is excessive. And the problem again is there's no evidence to give the jury if it's excluded on our side, and the evidence that the jury gets from the plaintiff is faulty, for lack of a better word. It's fantasy. I mean, yes, Real Water dreamed of the day when it could become a multi-million-dollar company. Maybe they dreamed of becoming a billion-dollar company, but they never were. And so to put that kind of punishment and deterrence on a $9 million company it's inequitable. It's just too much. So I don't really have anything else to add. I think we've kind of addressed this, but go ahead, Mr. Parker, if you got something else.
Your Honor, if I could, I just want to make sure for the record, we're not simply talking about punishing Real Water. We're also talking about deterring others in this industry. I think Mr. Abdul, and I may be incorrect here, is suggesting that the language is for deterrence and punishment of the same defendant. That's not the case. And we had this conversation, or we had this come up before yourself, Your Honor, first, and everyone else. The language is not just to punish and deter Real Water. That language is to punish Real Water and deter others within this industry from doing and committing the same misconduct. That's the purpose of it. So we're trying to put a number out there that deter Pepsi-Cola, Coca-Cola, Aquafina, whoever it might be, from committing the same type of egregious conduct. The other point, Your Honor, which is just by way of example, when you look at Boeing or Ford, it wasn't just to punish Ford and deter Ford from doing this in the future. It was to tell every other automaker, don't put the gas tanks that close to the rear bumper because of what could happen. And it was for the benefit of all people in this country to be safe. It's a public safety issue for everyone. And so, you know, that's why I believe the deterrence has to, that word has a meaning, and it's beyond simply Real Water. It involves the entire industry. And I appreciate that, Joel. You can go ahead.
Absolutely. The last thing I would say, Your Honor, in response to Mr.
Ted,
In response to Teddy's argument is, really the problem still exists that now we're running into two different interpretations of the Philip Morris case. We believe the Philip Morris case stands for the proposition that you can't punish real water for the conduct of other entities or try to deter entities outside the state of Nevada. That the state of Nevada can't be sending a message to Coca-Cola and its conduct in other states. And we don't read the Philip Morris case the same.
Okay, that's right, I was gonna say,
We disagree on the Philip Morris case in that regard. And it's been submitted, it's been cited to the court, and we just have a disagreement as to what it means.
I mean, ultimately, and I was thinking about this issue because I understand there's more issues, and I think that involved when it comes to punitive damages and the award, and I know we have the guardrails of constitutionality, I know we have punishment deterrence, and this is something that hasn't been discussed, we have annihilation is another factor the court has to consider, and typically that's done post the award, right? But what do I do when there's a bankruptcy? That's the whole thing that really I find perplexing at this point, because that's the big deal. You know, what do you do? Because technically, if you take it out to its logical extent, when you look at it from this perspective, if there's a filing of bankruptcy, then there's no longer an annihilation component to consider. There's no longer a punishment factor to consider because the company no longer exists. And just as important, there's no longer deterrence. And it seems to me that would stand for the proposition that once the company files bankruptcy, you can't award punitive damages at all.
That's certainly an argument that we've made, and we've made the argument that punitive damages have been awarded in the other three cases, so now we're punishing
No, I
them
understand.
for the fourth time.
I know, ultimately, these will all get put in a big basket if they don't
Yes.
settle. That's kind of where I think it's gonna go.
Yes.
And so what do I do? This is what I'm gonna do. I'm gonna permit the language, but this is kind of, I feel there are strong guardrails in place in this respect. Because at the end of the day, there's a constitutional mandate that there has to be some sort of nexus between the compensatory damages and the amount of punitive damages, right? We have a verdict.
Yes, Your Honor.
Whoa. I'm gonna permit the instruction, so I guess we might as well get set up and get ready.
So, Your Honor, were you saying you were approving the?
Yes, the instruction, I'm gonna go with the same instruction.
Okay.
But I
thank you.
just, what I wanted to do was, Mr. Parker, discuss on the record, the dilemma that faces me. Because, I mean, are we saying that, okay, what happens to annihilation, deterrence, and punishment if someone's filed bankruptcy? Those are no longer components to consider, then consequently, there would be no need for punitive damages under those circumstances.
That's exactly right.
Yeah, you know, and so, I'm just gonna permit it, we'll see what happens in the Supreme Court. But at the end of the day, my point is, there still has to be a correlation between compensatory damages and the punitive damages.
That's
Right, it has to be. I mean, hypothetically, I mean, it depends on how the case comes down, I could go 1-to-1 or 1-to-5, and that would, regardless, that would put, and the Supreme Court would hold that up.
That's correct, Your Honor.
Yeah.
That is exactly so.
You wanna go wash your hands and do something real quick before I bring the jury in?
Yes, Your Honor, it'd be nice to take a quick break.
I'm gonna let you take a break.
Get organized.
Get organized.
All right,
Yeah, I'll let you get organized.
Oh, that's good.
I don't know.
Fast. I didn't expect that.
As far as tomorrow's concerned, what time should we have them come back?
For the punitive damages, Vince?
Yes.
Judge, I thought we were ready right now.
Are you ready to do it right
Yeah,
now?
we're ready right now.
Look at Mr. Parker's eyes. Yeah.
Yeah, we prefer to do it tomorrow. My trial presenter's 30 minutes away.
You what?
Our presenter's 30 minutes away.
Okay,
I'd like to be a little bit more organized and just do it on the fly.
I understand.
We will have the money order, I guess.
For the,
Yeah, we're
being
gonna-
delivered.
Yeah, yeah, but we'll, how's 10:30 tomorrow?
That sounds good.
Is that fine, Mr. Parker? I know you smiled when I said that.
Listen, I got my draft ready. I can use the polishing.
I just want to make sure you're.
You gave me the look.
Yes. So are we ready?
We're ready to go.
Yes, Your Honor.
You know what, I think maybe it's better because we don't want to rush.
Thank you. We don't.
Where's all my paper?
How long do you think your argument would, how long will your argument take? Mr. Parker, how long will your argument take?
Oh, the last time, like 20 minutes, Sean?
Okay. So do about the same?
Yeah.
In the testimony was 5 minutes, right?
Okay.
Very short.
And last but not least, yeah, lunch tomorrow too. Lunch will be ready by then.
We can bring lunch in front.
Yeah, I can arrange it.
They want berries.
There.
Yeah. Berries steakhouse.
Berries. Pushing their berries.
Oh,
Like berries and
strawberry.
cream.
Yeah, that was
What
what
is
they do.
this berry to,
Joe. Who you looking for?
Mr. Carter?
I think number 2. I think it's that.
it's got to be because she asked the
She wrote the question, that's true.
question.
She had to, yeah, she's already informed me.
Another question.
Yeah.
Miranda.
I have to control him.
Was it for the client screen?
Then what if they say there's not?
Then we don't have to worry about that.
I actually have a printed out copy of the verdict form.
Oh, that's right, we're looking at yours.
I stole it, like your pen. I stole it. I'm gonna run
How
out
long
of
did the
letters.
jury deliberate in the other case?
Days?
Yeah, about a day and a half each case.
Yeah, the jury's getting more efficient too.
Amazing.
I don't think the jury wants to come back tomorrow. I don't think the jury wants to come back tomorrow.
I don't think so. Judge, should we ask the jury if they want to finish today? I mean,
I'm killing Joe.
Well, yeah.
I sent my trial guy home, I thought we would,
But,
as early as
well, the
tomorrow.
only problem there is, I have motions in the morning too and all these
Okay.
things. Yeah, I have to prepare, right?
Yeah.
I was reading anti-SLAPP stuff on while I was, I gotta get ready.
You know what, Your Honor, they're not as important as us. Just wing that stuff. and just
I
get
don't know this guy.
You want me to read, right?
Yes.
I don't have motions pending tomorrow, so I'm in. Sorry.
All rise for the jury. Please be seated.
And just in case we haven't, let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll move to the defense.
Your Honor, Eric Kupperman, Will Kemp, Peggy Parker, and Brianna Switzer for plaintiffs.
Good afternoon, Your Honor. Joel Levy, Matt Kaufman, Eric Freeman on behalf of the Real Water Defendants.
All right, and gentlemen, thank you. And do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
All right, ladies and gentlemen of the jury, did you select a person to serve in the role as the foreperson? All right, and who is that? And Madam Foreperson, did the jury in this matter reach a verdict?
Yes, we did, Your Honor.
Okay, and could you hand that verdict to the court marshal, please? All right. I'm going to let the record reflect, I'm going to hand the special verdict form to the court clerk. And ma'am, will you take your time and read the verdict out loud?
Okay. District Court, Clark County, Nevada, case number A-21-A331776-B, Department 16. Hunter Brown individually, Pamela Brown individually, Carla Moreno individually, Yaniv Ita as Special Administrator of the Estate of Adir Ita, decedent. The Estate of Adir Ita, decedent, Monica Branch Noto individually, and Stephen Watkins individually, Tecante Henry, an individual, Gray Maynard, an individual, Sherry Rasmussen, an individual, Daniel Taylor, an individual, Trevor Abley, a minor child by and through his natural parents, Brian Abley and Sandra Abley, Daisy Wee, an individual, Vincent Link, an individual, Lorenzo Muniz, an individual, Brandy Wren, an individual, plaintiffs, First Affinity Lifestyles.com Incorporated, DBA Real Water, a Nevada Corporation, Real Water Incorporated, a Delaware Corporation, defendants. Special verdict form. We, the jury, return with the following verdict. Compensatory damages. 1. Fill in the amount of damages for each of the following plaintiffs' past physical and mental pain, suffering, anguish, disability, disfigurement, permanent injury, and loss of enjoyment of life. For Trevor Abley, $7,500,000. Monica Branch Noto, $6 million. Hunter Brown, $5 million. Pamela Brown, $4 million. Tecante Henry, $20 million. The Estate of Adir Ita, $5 million. Vincent Link, $5 million. Gray Maynard, $7,500,000. Carla Moreno, $5 million. Lorenzo Muniz, $6 million. Sherry Rasmussen, $5,500,000. Daniel Taylor, $5 million. Stephen Watkins, $5 million. Daisy Wade, $8,500,000. Brandy Wren, $5 million. Fill in the amount of damages for each of the following plaintiffs' future physical and mental pain, suffering, anguish, disability, and loss of enjoyment of life. Trevor Abley, $7,500,000. Monica Branch Noto, $6 million. Hunter Brown, $5 million. Pamela Brown, $4 million. Tecante Henry, $20 million. Vincent Link, $5 million. Gray Maynard, $7,500,000. Carla Moreno, $5 million. Lorenzo Muniz, $6 million. Sherry Rasmussen, $5,500,000. Daniel Taylor, $5 million. Stephen Watkins, $5 million. Daisy Wade, $8,500,000. Brandy Wren, $5 million. fill in the amount of damages for Tecate Henry's loss of life expectancy. Tecate Henry, $35 million. Punitive damages. Is Real Water liable for punitive damages? Yes. Dated this 22nd day of October 2024, jury foreperson signed.
Okay, thank you, ma'am. And, yes, go ahead.
Ladies and gentlemen of the jury, is this your verdict as read?
Yes.
Are you from the jury?
Yes, I'm gonna ask counsel, do you wanna have the jury poll?
Your Honor, may we approach really quickly?
Yes, you may.
Thank you, Your Honor. We do not need to poll the jury, thank you.
All right. And so, ladies and gentlemen of the jury, there's one more phase we have to go through, and I think you understand that, because Mr. Parker indicated during his closing at the very end, there would be one more part of the case if there were findings of punitive damages. And so, right now it's 3 o'clock, and I anticipate, and I don't want to keep you late, but tomorrow morning we can start at 10:30, and we'll be done tomorrow. As far as everything's concerned, we'll be done tomorrow, just like we were done today as far as the compensatory damage portion of the case is concerned. And so what we're gonna do is this: I'm gonna admonish you not to converse amongst yourselves or with anyone else on any subject connected with the trial, or to read, watch, or listen to any report or commentary on the trial of any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media, or to form or express any opinion on any subject connected with the trial until the cause is finally submitted to you. And 10:30 tomorrow, ready to go, counsel?
Yes, Your Honor.
Yes, Your Honor.
Okay, all right.
All rest with part of the jury. Come on back here. Come on back here. Over here. Jury is clear?
Okay, thank you, sir. And for the record, I just want to make sure it's clear in case it was overlooked. The alternates and the dismissed panel member, who was that?
Garcia.
Mr. Garcia. They didn't participate in the jury deliberation. We kept them separate and distinct in the south jury deliberation room. The actual jury deliberated in the north jury deliberation room, so that's clear for the.
Thank you for putting that on the record, Your Honor, we appreciate that.
I have a question then. Did one of the original alternates then become a juror in
Yes.
place of Mr. Garcia? Because that was all bench conference. I didn't hear any of that.
Yes.
Thank you. So what was that then, that change?
For the record, he was removed and the next, and mine moved up.
Let's see. Okay, so badge number 36, seat 9, Debbie McDade then participated as the jury and
Yes.
Christopher Garcia became an alternate?
Yes, we agree.
I will make that change.
Thank
All right.
you, thanks, everyone.
What's that total?
230 million?
230. How does that compare to the other
That's
case?
the biggest ever. I was just telling Mr. Kemp that.
Are we still on the record?
Yes.
Can we go off the record?
Yeah, we can.
Yes.